Hello everyone, I am Chandni Bajaj and I welcome you all to yet another interesting episode of our legal awareness series, that is Just Justice. Progressing through our lives, we have often come across this word of caution, which says, a little knowledge is a dangerous thing. So keeping this caution in our mind, we have come here to continue with the topic of Hindu law. In the previous episodes, we have learned the concepts of marriage and adoption. In today's topic, we shall be dealing with the concept of guardianship. For this, we have with us in the studio our esteemed legal expert, Dr. Gaganpreet. Ma'am, we welcome you here.
Thank you. Thanks for inviting me.
So, as I introduced that we shall be talking about the concept of guardianship. Now, without taking any further time, I would like to ask you, Dr. Gagan, what is the term guardianship? What does it implies?
See, as far as in the layman's language, guardian is appointed for a minor. Reason being, a minor, according to the Indian Majority Act, a person who has not attained the age of 18, that person, any person who is below the age of 18 is a minor, and upon the attainment of the age of 18 years, person becomes a major. And as per law, a minor is incompetent to represent himself or herself in that capacity. So, somebody is to take care of that minor. So, as far as guardian in the layman's language is a person who takes care of the person of the minor as well as the property of the minor. And as regards guardianship is concerned, we have Guardians and Wards Act 1890, and guardianship is also dealt under the different personal laws. Like under the Hindu law, we have Hindu Minority and Guardianship Act 1956, and under the Muslim personal law, we have the traditional concept of guardian, and under Muslim law, we have the concept of guardianship for the purposes of marriage, guardianship for the purposes of custody, and the concept is elaborately dealt under different heads under the Muslim personal law. But as regards Hindu law is concerned, we have this concept of guardianship has been clearly stated under this Hindu Minority and Guardianship Act 1956, and guardian is a person who is appointed for the care and protection of a minor, and it is also for the person. When I say person, it means taking care of day-to-day activities of that minor, and when I say guardianship for the property, that means for taking care of the property of the minor. So, that is in general I can state with regard to guardianship.
Yes, ma'am. This brings us greater clarity on the term guardianship. So, ma'am, this brings me to my next question, which is, what is the difference between the term adoption and guardianship?
There is a stark difference between adoption and guardianship. In the previous episodes, we have dealt in detail with the concept of adoption. But to answer your question here, adoption means a child is uprooted from the natural family or from the natural parents to the adoptive family. That means all the links with the natural family, they are severed off, and the child is taken in a new family, and for all purposes, legal purposes, the adoptive parents, they will be considered as the parents of that adopted child or even the guardian of that adopted child. But as regards guardianship is concerned, in the very beginning I told you that guardianship is for a minor. That is till the child has not attained the age of 18 years, and in certain circumstances under the Guardians and Wards Act, if the in certain special circumstances where the child is suffering from some kind of unsoundness, and in that case it is 21 years. But as per the Hindu personal law is going on, the guardian is only for the minority. Once the child attains the age of majority, there is no requirement of a guardian. But in adoption, once the child has been adopted, for all times to come, the adoptive parents are going to remain the parents of that child, and it's like such an relationship which is irrevocable. But guardianship will come to an end once the child attains the age of majority, because as per the Indian law, once a child has attained the age of majority, he is competent to take care of himself, he is competent to contract, he is competent to represent himself or herself in all capacities. So that is the basic difference between adoption and guardianship.
Okay, ma'am. So quite often than not, we have also heard that we have got ourselves clarity on the adoption and guardianship point, but more often than not, the words custody and guardianship, they have also been used interchangeably. What do we have to say about that?
Yes, as regards your question that whether custody and guardianship can be interchangeably used, it is not so. Reason being that custody of the child, it can be with one of the parent, and guardianship as per the Hindu law, there are certain specified persons who are considered to be as guardian. Like for example, father is considered to be as the natural guardian of the minor child, or in other circumstances where is unfit, only in that situation the mother is considered to be as a natural guardian. But if the child is below the age of 5, then the custody of such a child can be granted to the mother. So it is the same child, the guardianship may lie with one parent and the custody may be with the other parent, keeping in mind the tender age of the child. In normal course, when we say custody, the question of custody normal arises in those situations where there is a matrimonial dispute. And in cases of matrimonial dispute, it happens that there is a fight between the husband and wife that they want to keep the child. So the court will decide, keeping in consideration the welfare of the child, because even in custody also the paramount consideration is the welfare of the child. So the parent who is competent enough, who has the resources and who has that kind of emotional attachment, keeping all these things, because selectively we cannot take one point, but collectively everything is to be taken into consideration by the court, and the court will give a decision that which parent is better contender for having the custody of the child. But as regards guardianship and custody is concerned, these are two distinct concepts.
Okay, ma'am. So does the child has any say in deciding which parent he wants to live or she wants to live with?
Yes, it's a very apt question. Yes, the courts do keep that in mind, and if the child is competent enough to answer that question, the wishes of that child are also taken into consideration. But as I told you, it's not so that only the emotional part will be taken into consideration. The overall welfare of that minor child is to be taken into consideration, because it may happen that the child has some emotional attachment with, let's say, the father, but the father does not have the means of the financial means to take care of the child, or let's say he is a drug addict who cannot take care of the child, or whatever may be the circumstances. Just this factor that the child is emotionally attached to one of the parent, and the in the court also, when it is asked by the sitting judge that with whom you want to stay, if the minor child say that okay, I want to be with this particular parent, but if the overall welfare or development of the child is not in the interest of that child, so in those cases the custody will not be granted to the parent of child's choice, basically. So choice is asked from the child, but it's not mandatory or it's not obligatory for the court to keep that in mind or to provide custody to that parent only.
Okay, ma'am. This was a very useful information. Yeah. So I would also want to know what kind of or how many different kinds of guardianships are provided as per the Hindu Minority and Guardianships Act.
So as regards the different types of guardians are concerned, under the Hindu Minority and Guardianship Act, we have natural guardians, testamentary guardians, de facto guardian are also mentioned, but now they are not in practice, or they are not, you can say, legally competent to deal with the property of the child. So, as regards the Hindu Minority and Guardianship Act, it is the natural guardian, where the father or the mother, as the case may be, they can be held as natural guardian, or in certain circumstances even the husband. But the testamentary guardian is there, then the court appointed guardians, which is in accordance with the provisions of the Guardians and Wards Act 1890. And let me tell you here that as regards the concept of guardianship under Hindu law is concerned, the different types of guardianship also, this act is not in derogation of the provisions of the Guardians and Wards Act. It is in place, it is intact, but we have a specific law only for the Hindus. So, it is, we say that this is the codified law for the use of Hindus, and we have dealt in detail the concept of Hindu as well in the previous episodes. And as regards the concept of guardianship is concerned, it is not in derogation of the principles provided under the Guardians and Wards Act. So, whatever is there, that is an additional thing, but it does not in any way try to cut off what is provided in that particular legislation.
Okay, ma'am. So it's like a general provision along with a special provision regarding guardianship.
Yes, there is, because as far as the procedural aspects, or when it is appointed, when a guardian is to be appointed by the court, or some formalities are to be provided or to be conducted, that has to be in accordance with the secular legislation only.
Okay. So I am sure our viewers really want to know that who is a natural guardian?
Yes, as I just mentioned briefly in the previous question as well, according to the Hindu Minority and Guardianship Act, natural guardian, as far as natural guardian is concerned, father is considered to be the natural guardian of his legitimate minor children, and to be more specific, for the son who has not attained the age of majority, and for a daughter who is unmarried. It's not provided that, it's not specifically provided that whether she has attained the age of majority or not, but as far as the act provides that for the unmarried daughter, father is the natural guardian at the very first place, and after him the mother. So, the sequence is that for the legitimate minor children, the father is considered to be as the natural guardian, but as regards illegitimate children are concerned, for them the mother is for the minor illegitimate children, mother is considered as the natural guardian, and after him the putative father that will be considered to be as a natural guardian. So, there is a difference in the sequence when we see the concept of legitimacy or illegitimacy. For legitimate children, father is at the first place and after him the mother, but in case of illegitimate children, the natural guardian is the mother. And you will be surprised to know that the act also provides, as regards natural guardian is concerned, husband is also considered to be as a natural guardian of a minor wife. Now, this is again a very tricky situation, you can say. On one hand, we say that the child marriages, they are prohibited, and the age of marriage is also provided under the Hindu Marriage Act, that the girl should be of the age of 18 years and the boy should have attained the age of 21 years. But in practice, when we see, it is provided, another legislation is providing specifically that for a minor wife, husband can be a guardian. So, this is something which is, you can say, there is a conflict between the laws itself. On one hand, we do not want to promote child marriages, but as regards the guardianship is concerned, it is specifically provided that the husband is also one of the, it is specifically categorized under section 6 of the Hindu Minority and Guardianship Act under the concept of natural guardian. Husband is included in the concept of natural guardian.
This leads me to a question. What if the husband is also a minor?
So in that situation, and it has come up in different cases as well, in that situation, if the husband is also a minor, then the father of that minor husband is to be treated as a guardian of both of them, basically.
Okay.
So it's not because see, the wife is minor, the husband is minor. So for the minor husband, the father is the guardian. And because the husband is also minor, he cannot be the natural guardian of that minor wife. So in that situation, the ultimate responsibility or guardianship, it comes to the father-in-law. That is the father of the minor husband.
Okay. Also, I think the audience would want to know, in case where a wife has been abandoned or her husband dies, then who gets her guardianship?
So that is also a tricky situation, and it has been held in number of cases that in such situation also the guardianship has been provided to the father-in-law only.
Okay.
And not to the father of the minor. It is just because if you see the provisions also, father is the natural guardian of an unmarried daughter. It is specifically provided. It's not provided in case of a married daughter or a widowed daughter. Although yes, it has been a subject of debate as well, and in many cases there are contradictory decisions of the different high courts in that regard. But as regards this particular point is concerned, if we go by the literal interpretation of the law, the father-in-law is considered to be as the guardian of the minor widowed daughter-in-law, in case the or the husband has, where the husband has abandoned. In that situation, see, it is whether there is a case going on or whatever is there, then it's a different story. But in normal course, the father-in-law will be considered to be as the guardian.
Okay, ma'am. So also I wanted to ask, is the position of a natural guardian a fixed one, or are any disqualifications included in it?
See, as I told you, according to the provisions of the codified Hindu law, father or the mother, depending upon whether they are legitimate children or illegitimate children, they are considered to be as the natural guardian, and in certain circumstances the husband is the natural guardian of the minor wife. But there are disqualifications also attached in the same section, that if that guardian ceases to be a Hindu, because we are talking about Hindu law is applicable only to Hindu. And if the guardian himself or herself ceases to be a Hindu, then that person becomes incompetent to act as a guardian for the minor Hindu child. And another thing is, if the guardian has renounced the world and has become yati or a sannyasi, if he has totally renounced the world, in that situation also the person will be considered to be as disqualified from acting as the guardian. So reason here is that one thing is that Hindu law is applicable to Hindus, so that is a disqualification. That conversion to a non-Hindu religion will act as a disqualification. Second condition, which says that if the person has renounced the world and has adopted a different course of life, that is, he has adopted, he has become ascetic or he has become sannyasi, in that situation, that means now he does not have that interest in the worldly affairs, and he cannot take care of the child. And the whole idea of having this concept of guardianship is that the guardian should act in the best interest of the child. He should be the protector of the child. It's protector of the body of the child as well as the protector of the property of the child. And if that person has renounced himself from the world, then he cannot take that interest in the welfare of the child, and the whole idea is frustrated by that. So that acts as a disqualification for the acting as a guardian.
So as you explained, I would want to ask, in the former case, in case of conversion, if the person reconverts back into the Hindu religion, would they be accepted back as on the position of guardian?
See, the act does not specifically talk about this particular situation. It's not covered under any of the provisions of the Hindu Adoption and Maintenance Act. But the thing is that it will be seen by the court that whether this particular situation is to be considered, that if the person was earlier competent guardian, but now he has converted to a non-Hindu religion and he was disqualified, and again he has reconverted into the Hindu religion, or he has become a Hindu. So in that situation, it's the act is silent about it. So if in that situation, the sitting judge will evaluate all the things and will make a decision in that regard. But as regards the act is concerned, it is not specifically provided under the, although it has defined that who is a Hindu, and a very well reconversion is considered under the ambit of the term Hindu itself. But as regards this particular situation is concerned, it is not specifically told under the provisions of the law.
Okay, ma'am. This brings me to my question, that what are the legal duties, or let's say the general duties, which have been described as per the Act for the minor by the guardian?
See, as regards these are not specifically provided, but as being the guardian of a minor child, there are certain things which are expected from the guardian. One thing is having the capacity to take care of that child. The person has all the right. First is that with regard to the custody, when we say in normal course, the custody of the child is with the guardian. Exception is provided under section 6 of the Hindu Minority and Guardianship Act, that with respect to children who have not attained the age of 5 years, for them the preference will be given to the mother for the purposes of custody. But if the child is beyond the age of 5 years and the welfare of the child demands that the child should be with a particular parent, in that situation it will be the first duty is to take care of the child, and that care of the person of the child will be once the child custody of the child is with the guardian. So first thing is that to take care of the child, to take care of the needs of the child, that means to provide him with food, lodging, and with all the amenities of life, to provide him good education. These are the duties. They also come under the ambit of the duties of the guardian. Then with respect to the, if the guardianship is with respect, specifically with respect to the property, or even in cases of natural guardian, it is expected that if the child has certain property in his name, so to take care of that property as well, and to take all the decision in the interest of the child. So it is expected that the guardian will take care of the body of the minor as well as the property of the minor. Then in certain cases, it is said that the reasonable chastisement is also can be exercised by the guardian. That means where the minor child is wrong, to tell him that he is doing wrong. That is also one of his duties. It's not just that, okay, child is there and whatever he is saying, they have to do only that. This is also in the ultimate welfare of the child, that they have to stop the child where the child is wrong. And with respect to the property aspect is concerned, there are certain specific restrictions with regard to the guardianship with respect to the property. The guardian cannot deal freely with the property of the minor as if it's his own property. He has to protect the interest of the minor. He has to take care of the property of that minor. But he cannot think that, okay, this is my property only and I can give it to anybody, I can gift it to anybody. That is not so. So, the welfare main thing is, and the act also promotes this thing, that the paramount importance is with regard to the welfare of the child, and everything which comes under the welfare, that is the custody of the child, then with respect to providing with all the amenities of the life, providing him good education, and with respect to in certain cases also reasonable chastisement, and as regard to other day-to-day activities or the decisions which the minor has to take. So, he assists or she assists in that as well. So, these are certain things which are expected from a guardian.
So, this brings me to my next question. As part of legal duties, can any guardian bound a minor in some form of contract?
No, guardian has to take care of the minor child. He cannot bound, he cannot by his own act or his own conduct or the very fact that he has entered into some kind of contractual obligation, so he can bind the minor in that. It is totally, as I already mentioned, with regard to the property also, the guardian cannot intervene in the property of the minor. So, he cannot even bound that guardian with regard to any contractual obligation. And contract is contract can be entered by a major, and reason being that minor cannot comprehend the technicalities of the contractual obligation which the guardian has taken up, or saying that the guardian has taken up some contractual obligation in the interest of the minor child. By that we cannot bound it. It is always such kind of obligation that will be void at the instance of the minor. That cannot be, the guardian cannot go to the court and say that, okay, I entered this contractual obligation in the interest of the child, so the minor is bound by it. He cannot do so as per the provisions of the Hindu law.
So, any such contract would be void ab initio?
Yes, because it is not entered, first of all, is the minor is not competent enough to enter such kind of a contract, and here it is out of his own volition the guardian is acting, and he is entering into some contractual obligation. So, he cannot bound a minor in that contractual obligation.
This was very useful. Even though we are enjoying as much as learning about the new concepts, we have paucity of time. So, with this, we come to the end of this episode. In this today's episode, we have learned about various concepts regarding guardianship. Who is a natural guardian? What kind of guardianships are there? What are the duties of a natural guardian? Whether a guardian can bound a minor in a contract. Dr. Gagan, we are very pleased to have you here, and you have disseminated the very useful information to us. We thank you for being with us.
Thank you.
In the next episode, we promise you that we'll bring to you more about the guardianship laws. We'll get to know about the testamentary guardianship, de facto guardianship, and other aspects of guardianship. Till then, stay tuned with us.